Miss Channing, I realize one of the defendants, Mr. Briggs' company, Mando PLC, is a difficult abstraction to bring into a courtroom, but it's the other defendant, Mr. Briggs, not in court?
Yes, he is. He's here, my lord.
Yes, I see him there. I don't see him in the dock. I'm sure it seems unfair to you, Mr. Briggs, that we have to ask you to suffer the inevitable prejudice of being in the dock, but this is not a civil action. No doubt your legal team is unfamiliar with criminal procedure. You must surrender to the dock officer.
I have to do this.
You'd better do as you're told, Mike. Some of them are such pedantic twits.
Just speak up, please, Miss Channing.
I said if you insist, my lord.
Oh, I do. I can be pedantic to the point of twittery.
To concern himself with the day-to-day running of health and safety. One man can't reasonably do this in a company employing beyond a certain number where contact can't be made on an individual, first-name basis. Therefore, my client was wrongly indicted with this offence.
Yes. Yes, the authority is good. Might have carried your argument, Miss Channing, were it not for the fact of the directing mind. I think that Lord Justice Brockway and the Red Burger chain electrocution is a better authority here. Let me see if I remember this correctly. When an employee was electrocuted, the owner of the burger chain was indicted for manslaughter, having been the directing mind. He told the manager of the branch not to waste time and money checking all of the equipment. Lord Justice Brockway spelled out the rule very clearly. When a company director is on site and becomes personally involved in health and safety matters, and especially when it also involves cost-cutting measures, then he or she is bound to be held legally responsible. So I think your argument, founded upon Bridge and Newways, falls when counterposed here with Lord Justice Brockway. Let's have the jury back.
My lord, I think Lord Denning is the higher authority on this.
Your rank doesn't count in the Court of Appeal. All their judgments are equal. I remind you that I have ruled on this.
I would like an adjournment to refer this elsewhere.
Well, I would have thought that even you would know that in a criminal trial on indictment, the right to appeal any aspect only arises at the conclusion of the case.
This is pure prejudice. You're not being fair to my client.
If you seek to disrupt these proceedings with spurious argument, I will hold you in contempt.
I hold you in contempt for what you're doing.
Miss Channing, if you continue, I'll have you removed.
You're being childish
Will
and
the dock
contemptible.
officer remove Miss Channing to the cells, please? Right.
Isn't it true to say, Mr. Forsyth, that the whole thrust of your evidence is characterized by the fact that you are trying to wriggle free from all responsibility?
No. I'm indicating where responsibility lay.
Well, didn't you plead guilty in your own trial in return for a non-custodial sentence, provided you gave evidence against Mr. Briggs?
No. No, I pleaded guilty to the extent of my responsibility.
Do you seriously expect the jury to believe that an experienced site manager doesn't have overall responsibility for safety?
Look, Mr. Briggs told us to ignore anything that delayed progress. Now, he would have fired me if I had ignored him.
As the judge so eloquently put it, your job was more important than a life.
No. Of course not.
Then why heed an order that ignored health and safety when in so doing you were breaking the law?
I was told to do so.
And doubtless told you could wriggle free if you drew someone more senior in. No further questions.
Mrs. Mills, how do you propose to secure the evidence?
If I might have a short adjournment.
10 minutes?
I'm obliged.
10 minutes, Mr. Harrison.
It is no